Good morning, everyone. Welcome to the Supreme Court of the United Kingdom. I am Lady Arden, and I'm one of the Justices of the Supreme Court. And today, I have the honour of telling you about our new decision in the matter of the Crown on the application of Maughan, Appellant, and Her Majesty's Senior Coroner for Oxfordshire, Respondent, and the Chief Coroner for England and Wales, and the charity Inquest have intervened with the permission of the court. This matter was heard by Lord Reid, the President of the Court, Lord Kerr, Lord Wilson, Lord Carnworth, and myself. The decision is on appeal from the Court of Appeal of England and Wales, and it's about whether, when a jury gives its conclusions at a coroner's inquest, the jury has to be satisfied as to the criminal standard of proof, that is, beyond all reasonable doubt, or whether it is sufficient for it to be satisfied as to the civil standard of proof. We have decided by a majority that this is a matter for the common law of England and Wales, and that it should be the civil standard throughout. Now, conclusions at a coroner's inquest can be given in one of two forms. There is the short form conclusion, such as unlawful killing or suicide. There is then the narrative conclusion, which sets out the findings as to the circumstances into a person's death. So there are these two forms. Coroner's inquests are not criminal trials. They have a very long history, coroner's inquests going right back to about 1196, but they have developed quite considerably recently. They are inquiries into when, where, and in what circumstances the deceased met his or her death. They are very important events because they are an opportunity to explain to the family what happened to their loved one, and also because they tell those in authority what happened so that measures can be taken which are appropriate to help prevent the same thing happening in future. This has led inevitably to juries and coroners giving longer and more judgmental conclusions than in the past. So if you attended a coroner's inquest many years ago and then attended one now, you may find that the process has changed considerably. Inquests have changed, and in part due to the influence of the European Court of Human Rights. I have to begin by summarizing the circumstances in this appeal, which are tragic. The position is that the appellant's brother was at HMP Bullingdon, and he was found dead, and the question arose as to how he had come by his death. There had to be an inquest, as I have explained, into the circumstances of his death, and that inquest was before the Senior Coroner for Oxfordshire. Obviously, in these circumstances, our thoughts go to the family of the deceased for this very sad event. At the inquest, which was held on the death occurred on the 11th of July 2016, and there was then, as I have explained, an inquest. And the Senior Coroner for Oxfordshire decided that the jury could not safely reach a short-form conclusion of suicide. This was because the jury could not be sure, beyond reasonable doubt, that Mr. James Maughan, the deceased, had intended to kill himself. So the coroner put to the jury certain questions and asked them to make a narrative statement of the circumstances in which the deceased had met his death on a balance of probabilities. The jury answered the questions put to them by saying that he had a history of mental health issues and that on a balance of probabilities, he intended fatally to hang himself, and that increased vigilance would not have prevented his death. Now, the appellant is the brother of the deceased Mr. Maughan, and the appellant, Mr. Maughan, went to court to establish that the jury's conclusion was unlawful. He argued that the senior coroner was wrong to instruct the jury to apply the civil standard of proof when considering how the deceased had met his death. Now, this is the second appeal, so there have already been two hearings in two different courts. The first was in the Divisional Court of the High Court of Justice. The Divisional Court dismissed the appellant's application, holding that the standard of proof for short form and narrative conclusions of suicide was the civil standard. The Court of Appeal upheld the Divisional Court's judgment. That was the second court, Court of Appeal of England and Wales. They upheld the Divisional Court's judgment and went on to hold that the civil standard applied also to unlawful killing, although unlawful killing is not an issue in this case. The appellant, Mr. Maughan, then obtained permission to appeal to the Supreme Court, and the Supreme Court permitted the Chief Coroner of England and Wales and the charity Inquest to intervene, and it is grateful for the assistance that they have both given. Now, the Supreme Court is giving its decision today, and in essence, the Supreme Court by a majority agreed with the courts below. But it was by a majority, so what I am saying to start with is a summary of what the majority say. I give the first judgment, with which Lord Wilson agrees. Lord Carnworth also agrees with my judgment, but he gives a further judgment, which I shall also summarize. In essence, we decide that the standard of proof for all short-form conclusions at an inquest is the balance of probabilities. The civil standard, therefore, applies. In my judgment, I explain that there's no provision of any primary legislation passed by Parliament which sets down the standard of proof in these circumstances. The primary legislation is called the Coroners and Justice Act 2009. I also make the point that there isn't any requirement under the European Convention on Human Rights that there should be either the civil standard or the criminal standard. Clearly has to be a standard, but the European Convention on Human Rights does not specify one or other standard. There is case law, and the case law is to the effect that conclusions of suicide and unlawful killing should be reached on the criminal standard. And I will have to come back to that case law in a moment. The position, however, is that the coroner's verdict is not a criminal proceeding. Also, the Coroner's Inquest Rules 2013, which were made under authority given by Parliament, contain a form, a prescribed form, which must be used to record the result of an inquest. Now, this is very important. This is an important point which was covered in the courts below, but is covered in more detail in the Supreme Court. Now, this form contains a number of notes, and note 3 to this form is the one with which we're most concerned. It explains that the standard of proof for short-form conclusions of suicide and unlawful killing is the criminal standard, and for other conclusions, the civil standard applies. So the note says, short-form conclusions of suicide and unlawful killing is the criminal standard. There is no question, but Parliament Parliament could have made a rule about the standard of proof in these rules. That is because, in my judgment, I adopt the reasoning of Lord Justice Wilson, as he then was, in an earlier case, in which he decides that this is a matter of practice or procedure, and that is the scope for the rules that can be made. There's also no question that a footnote can lay down a legal rule. But the case which establishes that, which is called Hunt and Douglas, it contained very different circumstances and is distinguishable in the view of the majority. The issue is whether or not the effect of Note 3 is to require the criminal standard. And that became the principal issue in the Supreme Court. Now, to decide this issue, I look at the context to the making of the 2013 rules. The Ministry of Justice consulted on the rules in draft. The Ministry of Justice's response document explained that case law had established the standard of proof and that the rules could not change the law. I find that that response is relevant to interpreting Note 3. I find that the response shows that Parliament did not intend to change or to codify the common law as it was understood to be. Indeed, I go on to say that the contrary result in this case would contravene drafting conventions on which our unwritten constitution depends. And I cite Lord Thring, one of the first head of the Parliamentary Council's office, and he says that it is improper to put matters of principle into a schedule. So I conclude that on its true construction, Note 3 did not take away the power of the courts to develop our common law. I further conclude that consistently with legal principle, the civil standard of proof applies to short-form conclusions of suicide. The previous case law, I referred to that a moment ago, is not binding on the Supreme Court, and moreover, when it's analysed, it does not identify a good reason against applying the civil standard. If we apply different standards of proof for short-form conclusions and narrative conclusions, there is the risk of an internally inconsistent system of fact-finding. Moreover, if the criminal standard of proof is required, suicide is likely to be under-recorded. There'll be fewer conclusions that suicide is what happened. On this, I point out that societal attitudes to suicide are changing, and the role of inquests has developed from what it was originally to be concerned with investigation into the circumstances of deaths, not with criminal justice. And I also take into account that certain Commonwealth jurisdictions have aligned the standard of proof applicable in inquests with the standard of proof applicable in civil proceedings, which is the same result as is achieved by our decision today. As I have said, I hold that the civil standard of proof also applies to determinations of unlawful killing. There is then consistency between the determinations made at an inquest, however they are made, in whatever form. Lord Wilson has agreed with my judgment, so has Lord Carnworth, and Lord Carnworth gives a concurring judgment in which he considers that the Act does not indicate that the civil standard of proof cannot apply to a conclusion of suicide. In his view, Note 3 does not have that effect, and the public consultation materials confirm the position. Now, as I have explained, that is the view of the majority. What I'm going to turn to now is the views of the minority. The minority are Lord Kerr, who gives a dissenting judgment, with which Lord Reed, the President of the Supreme Court of the United Kingdom, agrees. They hold that the criminal standard of proof applies to both short form and narrative, to the short form conclusions of suicide and unlawful killing. They hold that there is no inconsistency caused by short form and narrative conclusions having different standards of proof. There is nothing in their judgment untoward in putting suicide and unlawful killing in a special category of verdicts that require proof to the criminal standard. Note 3 to the form did not attempt to change the law, but confirmed what the existing law was, and as a result, in their view, the common law has become a statutory rule which can only cease to have effect if Parliament changes it. The rules have unquestionably, in their judgment, established a statutory basis for the application of the criminal standard of proof for short-form conclusions of suicide and unlawful killing. So I have now summarized the judgments of the Supreme Court in this matter. I'm very grateful to you for giving this matter your attention, and the court is now adjourned.